For more on this, we're joined via Zoom by legal and transformation practitioner, Mr. Thabo Masombuka. A very good afternoon to you, sir. Thanks very much for joining us here on SABC News.
Good afternoon, Floyd. Your viewers, thank you very much.
You're most welcome. You know, maybe you can explain to us whether it is a bizarre set of circumstances that we are sitting with two dockets, pardon me, for one case. Why would that have been the case? Is this something that, you know, is something that generally does happen, or is this actually as bizarre as we assume that it is?
Thank you very much, Flo. It is not unusual that you can have more than one docket in a same or similar set of circumstances of a criminal nature, especially when there are various complainants and different investigators. But what is bizarre and surprising is that you would have one set of accused preferred instead of the other. So what we have seen happening and unfolding last week is that there has been talk of this docket that exists somewhere else until it was brought to the attention of all defense counsel. When I say all, I mean for all the accused, to their attention only last week. And it is on those bases that advocate Mshololo had to request for a postponement, legitimately and correctly so, to be able to not only view the contents, but also take full instructions from her client, and then be able to make a decision on what type of legal advice she can be able to offer. So what we will see happening tomorrow is not a proceeding with the cross-examination, but it's an announcement by Advocate Mshololo on whether or not, based on the written correspondence, because she, on behalf of her client, is entitled to know on what basis was her client and not the other ones implicated on the other documents preferred for criminal prosecution when the others are not. So there is a little bit of misjoinder here. And the National Prosecution Authority has, in fact, has got egg on its face to explain what really happened, why they preferred one set of accused instead of the other.
Yeah, and you know, I was reading an article talking about the case, and what the article was saying was that the state's case has been weakened, and one would think, yes, in terms of the prosecution of these particular five, that this docket is now being brought into question. But one would think that the state would want to get to the bottom of this case, and if there is a docket that's saying actually there's other people that we should be looking into and other people that should then be investigated, shouldn't the state be, you know, relieved to hear that perhaps we can get to the bottom of the case? It might not be these people you've pointed to, these five people that you've pointed to, but certainly there's more information and perhaps even more proof that there's other people that are indeed involved in this case. Why would one assume that the state's case is weakened when this could actually be a strength in that they can get to the bottom of what actually happened to the late goalkeeper?
In law, there's something called Dominus litis.
Yeah.
The state is the Dominus litis. What that means is that they have the legislative right to commence, to start the criminal prosecution against anyone based on complaint and based on evidence available at their disposal. And they are the only ones who can discontinue those criminal proceedings. The state's case in this instance is weakened to the extent that it is arguable that they've done what is called fishing expedition. So in other words, you throw a net, you will see how many fishes you can get out.
Yeah.
So in other words, what they've done, they have went into a dark room looking for black cats through the prosecution of these guys. So it is correct for the defense to raise the issue of the existence of another docket, because what it does, it raises the prospect of a reasonable explanation. Remember, when a person is charged in court, when a person is accused, he or she does not have a responsibility to prove his or her case defense beyond any reasonable doubt. Correct. But the state has. All that the defense or the accused person has to do is to explain or give a probable explanation. Now, in this instance, all those 5 accused have a sufficient probable explanation to give, to say, hold on, there exists another docket issued by another division of the same National Prosecution Authority. So there is likelihood that the state doesn't know what happened on that day. And when there's doubt, and whenever there's doubt, then the court is obliged to find and rule in favor of the accused in this instance. And this is where we're more likely to see injustice for Senzo Meyiwa, because already in the first state witness, as you could tell and see, there's substantial holes that have been made in the state case to the extent that the crime scene was contaminated. The very same expert witness of the state has considered and made admissions on several times to extend on how they actually couldn't protect the crime scene that they were supposed to. So there is a likelihood that there's reasonable doubt here as to who exactly did what on that particular night.
Yeah, and that brings me to my next question then. The fact that there has been a light shed on perhaps a different set of circumstances that may actually be tested in court. And as you rightly say, that there is this onus on the state to prove beyond a reasonable doubt that these particular 5 did indeed commit the crime. The fact that there is information already points to a loophole, already points to a fact that this burden, the beyond reasonable doubt burden that is placed on the state to prove that it already has problems. So, which means in a way that the states might have actually failed to prove that these 5 did in fact commit the crime. Is it not fair to say that this case is lost to the state then?
There is reason to believe that given the set of circumstances, that given the development of the whole journey, remember, the state has had more than 7 years? Not just to investigate, but also to bring charges before those that are reasonably suspected, beyond any reasonable doubt, to have committed this offense. The fact that the state initiated proceedings against 5 persons, and it later appears that there are probably other 6 or 7 persons, has already weakened the state case in such a way that in both sets of accused, they are more likely to walk up free, because they will come, even the next set of accused, for instance, can come to court and say, hold on, you suddenly are charging us just because this came into light when it was cross-examination. Why didn't you do it in the first place? So you're not even sure of what happened. The crime scene has been contaminated, and they've also have received what is called the benefit of knowing what has happened in court, in public gallery, and everyone has been able to watch the developments in court. So already the state here is limping from one disaster to another. Yeah. They are frog leaping themselves from one crisis to another. So it's quite sad that Senzo Meyiwa, his father, most of the South African people who were legitimately and reasonably expecting justice to see itself happening will actually never get the truth of what exactly happened, just because through its own institutional instrumentality, the state has able to not just contaminate the crime scene, but has been able to corrupt the process. The process is extremely corrupted. just by the decision-making process of who to charge and who not to charge.
I know my team is telling me to wrap up, but just a quick one here. When it comes to the second docket and the new information that is now will indeed come to light from that new docket, of course, it's also pointing to the fact that perhaps those that are in the house should have been charged in the first place. Would we find, or could we find ourselves in a situation where new people are charged and we have to then begin a new trial on this particular case? How do you see it playing out should this case, well, the trial that we're dealing with now, should it have to be flushed out?
Now, back to the statement I made earlier about the Dominus litis.
Yeah.
The state has constitutional and legislative authority to decide who to charge, when to charge them, how to charge them, all right? So they can, of course, drop charges against the current accused and bring new charges against the other suspected persons in the other docket. But what does that now do in front of the court of public opinion, in front of the law, in front of everyone? It weakens them even further to say, but you don't know what you're dealing with. You actually fishing, expediting yourself here. You're actually trying to get yourself luck. And the law does not allow a situation where people are tried, people are accused, standing, because you see, this is murder here. Anyone found guilty of this type of offense is more likely to receive a life sentence. So what that means is that you can't gamble with the life of individuals, especially whose rights are constitutionally entrenched. So in either way, it's a crossroad for the state. Whichever direction they take, their case and the strength of their merit has been weakened drastically just by mere decision-making that they've made, incorrect as it was.
All right. It was such a pleasure to have you on the show. I hope we'll certainly be having more communications regarding legal matters as they unfold, and in particular this case. Thanks very much for your time, so we appreciate it.
My pleasure.
All right, that is Thabo Masombuka, who is a legal and a transformation practitioner, weighing in on the second docket that has certainly come to light in the Senzo Meyiwa murder trial that was disclosed to the High Court in Pretoria. And we'll certainly see how it all plays out in this week, as no doubt SABC News will be carrying that for you live.